Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Let's go a little bit down my street to Buffalo, New York. And I'm gonna, before I get into this, this is very, cutting edge in the sense of just happened. But before I get into this, let me just comment. Hey, I live in New York. Don't come firebomb my house. I'm not attacking anybody. If you watch last week's episode, this is going to relate to some of the topics we talked about with the firefighters rule and such, and the week before, I think, too. But I have a lot of questions about this suit, so I just want to raise the issues. I'm not trying to attack the widow in any way. Please, we're only discussing the legal issues about this. So here in Buffalo, we have a line of duty death on March 1st of 23. The widow is now suing and sued the contractor, which I think is very interesting, the city of Buffalo itself, and they're accusing them of negligence and wrongful death. I want to go through the allegations a little bit, and then you and I can kind of jump in with our defenses, because my bet is this gets dismissed.
Yeah, I didn't include, at least in the write-up, I didn't include a lot of the allegations against, I didn't include any of the allegations against the contractor or the building owner. I really focused more on the department. But if people go on, and this is something that it frustrates me sometimes, where people only read the headline. They don't read the whole story. And you can't just read the headline. You can't just read the post. Go on and read the complaint, and you'll get a lot more out of it. And that's going to be a theme that we see in several of the other stories this week as well. You got to go beyond the headlines. But I focused on the post, on the allegations against the fire department, because I think that it's really important that chiefs out there think this through. And if I'm the chief of a department, how am I going to defend myself if we have a line of duty death and these allegations are made against me? Can I refute that? Do I have the documentation that is going to refute each of these allegations?
And we have the court of public opinion, which I think is the only place, frankly, where the widow wins here. But we also have the court of law. So here what happened is, when you read the lawsuit, it is basically just a recitation of 1910-126, the fire brigade standard, which in New York, by a case called Ballston Spa, the New York court said, look, the fire brigade rule, a federal standard, federal regulations, is applicable to both paid and volunteer fire departments in New York State. So here we have a paid department, City of Buffalo, but it claims that the city failed to basically comply with the entire fire brigade standard, right down to the 2 in, 2 out rule, which I was really shocked about, but nonetheless, they just took the whole fire brigade standard and said, these are all the things you did wrong. So basically, they're alleging negligent supervision, negligent training. The problem we have here is, in New York State, like most other states, you can't sue your employer. So, and I'll throw out a possibility here, but you can't sue your employer. So how do you get around that? In a case
you can't sue in tort.
Right.
Okay. So that's where a lot of times in a case like this, we'll see constitutional claims, due process violations, and so on. But you can't sue in tort for
meaning negligence.
You can sue your employer in tort due to workers' comp exclusivity.
And here, that's what they're doing. They're saying our employer was negligent or failed to, adhere to all these federal standards. The problem is you can't sue based on that. However, and that's not what I'm going to say is not alleged here, but in many, many years ago, my department and neighboring departments was sued for a line of duty death. And I said, there is no chance it's going to win. Except the appellate court came out, and I wrote an article in Fire Engineering, and you and I and a million others have discussed this, and the article's still floating around out there, interestingly enough. But the rule in New York State, you can't sue your employer, right? Then it is pretty much absolute. If you can find someone else to sue, like the contractor, building owner, maybe, and I still want to talk about them anyway. But one way you get around this is you find somebody else other than your employer to sue for it. Here, it's the city of Buffalo. I don't know how you're going to do that. And most of these failure to comply with federal law, they don't win the day, right? Yes, you failed to comply with federal law, and OSHA may come in and tell you, or New York State PASH, but state OSHA, but they may come in and say you didn't do things right. Now, there's a federal law nobody ever thinks about. Won't come into play here, but is NIMS. And everyone's like, well, why would you bring up NIMS? Well, because NIMS has certain standards which are also mandated by law. One of them that could be applicable here is the incident command system. You have to check in. You can't freelance. Right? It's hard to tell exactly what specifically they say caused this death, but on the part of the fire department. But even there, if you cite federal standards, you can't do it against your own employer. So that case that I'm citing, where they use NIMS and whatever, it still recognizes you can't raise federal standards against your own employer. It doesn't work to get around the workers' comp rule. So I don't think this survives a motion to dismiss with the city of Buffalo. And I'm a little shocked. I even looked at the law firm to see, if they do this kind of stuff. I'm a little shocked that they are suing the city, because I'm going to be curious how you win. But the contractor is a different issue, except for something you said last week. So unless you want to talk about the city, let's talk about the contractor for a second.
Yeah, well, I think before you get to that, kind of jumping around here, but I think there's a strategic issue trying to get my mind, in line with what their attorney, the attorney who represented the widow, do we go after the contractor and the building owner, or do we just go after the fire department? And what happens here is when you make allegations against both of them, they're both going to be pointing the finger at each other. And I think sometimes you have a strategic decision. Are we better off just going after the contractor and just focusing on their negligence? And then if they want to bring the fire department in, they can bring the fire department in. Or do we bring in the fire department, just go after the fire department? In both of these cases, if you're going after the contractor and the property owner, we're dealing with the fireman's rule that we talked about last week.
Yeah.
Okay. So that's sort of issue number one. If you go after the fire department, you've got this workers' comp exclusivity, possibly sovereign immunity, and so on. So you've got some other defenses over there. And so there's a strategic. Their option was to do, I think, the typical what they expect on a law school exam is you go after everybody. And that's what they did. They went after everybody. But now you give them the opportunity to point the fingers. Besides their individual defenses, they would be pointing the finger saying, well, if the fire department, the building owner is going to say, if the fire department had their act together, this wouldn't have happened. They're the proximate cause. And the fire department's going to say, no, if they hadn't started the fire or they maintained the building properly, even if we were an awful fire, which Buffalo isn't an awful fire department, but if they were to allege that, if the building didn't catch fire or the building was properly maintained, our guy wouldn't have died as well. So now it just turns into this big mess.
But I'll tell you why that's a horrible idea.
Yeah.
Because think what's going to happen let's assume city of Buffalo gets out of this.
Yeah.
Right. Because I think that's what's going to happen.
Mm-hmm.
But you're in front of the jury now on the contractor. Now, I think they're going to get rid of the contractor too. Well, but we'll talk about that in a second. But now assume for a moment the contractor's there, because you always have to think of your case from day one. You have to think of day end, meaning what's the last day you're presenting in front of a jury. And if it's me, they just raised the plaintiff. And I think they made a fatal mistake in front of a jury. The plaintiff just said, hey guys, look at all the things the fire department did wrong. And now what they did is they just cut the legs out of the contractor, because the contractor, even if the contractor is found liable, and I'm sorry, they cut their legs off of their case against the contractor, because even if the contractor is liable, they can now apportion liability to the city saying, yeah, but had you done all these things, you would have only been 10% liable or whatever. So I think this was a horrible jury mistake. They're going to divert the jury's attention to the city where they couldn't have won in the first place.
Yeah, it'll be interesting. And I think the point, I kind of jumped around and I cut you off when we were going to talk about the fireman's rule and the general fireman's rule. If you want to talk about it, the general rule is that when you're a firefighter and you go to an emergency, you can't sue anyone. That's sort of the general rule. Then we have all these slice and dice exceptions that different states have. Some states say you can't sue the person who caused the fire, but you can sue anybody else. And then there's some that say you can't sue the property owner of the property that caught fire, but you could sue the person who caused it if they were not the property owner. And all these different exceptions. Somebody could write a book just on the fireman's rule.
Yeah, and the Black Sunday cases review a lot of that, where they're trying to hold the apartment owner and contractors all liable criminally and civilly for the Black Sunday deaths.
Yeah. So, at the end of the day, and I don't know if you're ready to kind of speak on New York's take on that, but I'm interested to hear, because I'm not up on each of the specifics of each state's interpretation of the fireman's rule. So where do we stand on that?
They're losing in the fireman's rule.
Really?
We could pull up, if I was better prepared, I would pull up the Black Sunday cases where they tried this exact thing. But look, in New York and many other states, right? It's one thing and we talked about this last week. So let's talk more generally. Even, what we said last week was, as you're saying here, it's one thing where the property owner leaves their property in a dangerous situation such that after the fire department responds, they encounter a dangerous situation, just like, ice on the driveway, or in the case we did, there's no drywall and the studs are missing to prevent someone to go over a staircase, right? So let's say where there's a hole in the floor that, a firefighter shouldn't have expected there to be just a gaping hole, not from the fire, right? But just there's a hole in the floor. So where a property owner creates a dangerous condition that injures somebody, regardless of whether there would have been a fire there or not, right? The property was just in a dangerous state. You could sue. But here, I think what they're saying against the contractor, I'll be a little cautious, is basically they caused the events that caused the fire. I don't think, right? And Black Sunday was a little different, because they're saying, well, they carved up the building in such a manner and didn't comply with code and all these criminal and civil violations. And because the building was cut up, that's what caused the firefighters to become, have to jump
and in Black Sunday, they were going under a statutory violation, not necessarily tort negligence. They were saying you violated a statute which provides for a remedy for statutory violation, which arguably is an exception to the fireman's rule.
Yeah, and right, and they tried civil penalties, not a lawsuit. Well, they tried lawsuits too, right? But in any event, here the short answer is you are generally not going to win against a building owner and maybe even a contractor based on something that caused the fire, right? If they created a dangerous condition that if you invited a guest over, right, which is what you're doing when the fire department comes, they're called an invitee. It's like you're inviting a guest and they get hurt because your property condition, not because it's on fire, but because there's something that's happening in your property, like a gaping hole in the floor that shouldn't have been there, then you could be liable for that. And that's the New York rule, but that's many rules are similar to that. And I just don't think they're going to win as against the building owner. Now, the contractor is different, but there you still have no duty. The contractor owes the fire department and the firefighter no duty necessarily. The landowner does, a duty to maintain a safe environment. I don't know that suing the contractor is okay, but look, the
contractor started the fire. That's the problem. The contractor, it wasn't the contractor, miswired an electrical outlet that started the fire. They were using a propane torch that in turn started the fire.
And there's no liability for that. I mean, that's the fireman's rule. That's the whole point of it, right?
Well, yes and no. And again, every state's going to be a little bit different. I will tell you that there was a case about 10 years ago out of Buffalo also. Different fact pattern, but two firefighters get killed. They both sued. I was in touch with their attorney, and they both sued. They both got $1 million settlements against the city. They did. That's right. They did go after the building owner. I don't recall off the top of my head if they got a recovery from the building owner. And the reason I say that is in that lawsuit, one of the themes that they alleged was that the building owners were on the scene at the fire, which you notice that the complaint alleges that both the contractor and the building owner were at the scene or close by. But they were at the scene, and they failed to warn the firefighters of a dangerous condition that was in the building.
Different issue.
I gotcha. But the plaintiff's attorney put that in the complaint and kind of teed up that issue. Maybe to survive a motion for summary judgment.
Yeah,
maybe it's going to be their main.
That could do it.
Maybe it's going to be their main, avenue, their main strategy. But they want to get the duty to warn about a dangerous condition, and then the failure to alert them. And they made a couple of allegations in there. And again, I don't know what happened. I don't know all the details, but they made a point of saying that this firefighter had a radio and had the incident commander, had the building owner told, or the contractor told the incident commander that such and such happened, that he could have been in communication with the firefighter and warned him, and that did not happen. So,
and it's funny because here they talk about the 2 in, 2 out rule, right? Which says you have to be in visual and voice communication. And well, look, when you put water on a fire, there's no more visual, especially in a big building. So the question is, did they have voice communication? And that tees up another interesting issue that, okay, let's assume the contractor did tell or would have told. Would that have even mattered? Could they have had radio communications? We've seen other radio communication failure cases where
absolutely. Well, radio, once you lose comms with an interior crew, there's two parts of accountability. But once the incident commander or the division sector officer loses comms with the interior crew, you've got a 2 in, 2 out violation. Period. It's clear. Okay. But what happened here was the two in team separated, and the officer got away, and it kind of made it sound like it was an acting officer and he wasn't properly trained. And I don't know if that's true or not, but point being that this guy's buddy got out and he did not, and that could be a 2 in, 2 out violation as well, because now you've got a crew that's separated. So again, a lot of factual questions here. Yeah.
So look, we feel for everybody, obviously, on a duty death, and you want to, it's a dangerous job we do, right? So it's, my
take on this is I would encourage everybody to read that list of bullet points that I've got there. Those are the allegations that you screwed up. Now, whether or not they can prove it, whether or not they are going to be defenses that the city has, but I think I put them there. The reason I put them there is because I think that in the event you have a line of duty death, these are the allegations that you're going to be facing. And what you want to be able to do is say, okay, I'm going to be able to refute that with training records. I'm going to be able to refute that with our policy that prohibits that. Not only having the policy, but here's several reprimands that we've given to officers for not adhering to the accountability policy. Because if you've got an accountability policy and it's been in place for 20 years and no one's ever been disciplined for it, and I'm not saying fire somebody, I'm not saying suspend somebody, but I'm saying document that you hold people to it. Because many departments that I go into, and sometimes I have to go into review problems that happen, and I talk to folks, and they're not anywhere near pretending to be compliant with 2 in, 2 out. They don't even pretend. But then when I ask the chief, I put the chief on the witness stand, the chief, oh yes, we comply. And I'm like, it's disingenuous. Okay. So you've got to be able to show that you're actually enforcing your accountability procedure.
Agreed.